This is Mark Furman from Tarlow, Breed, Hart, and Rodgers, and is going to be speaking with us this afternoon about a very interesting case that was just adjudicated in the courts.
And he's our legal reporter too as well.
Yes.
So, Mark, welcome.
Jeffrey, Greg, nice to see you both. Wanted to talk today about a case that was decided by the Court of Appeals in the District of Columbia, one of the most influential Court of Appeals. The other day they struck down the appointment of 3 members of the National Labor Relations Board as invalid. This is, I usually talk about cases that are specific to business, but this is one of those important cases, I think. Remember, we talked about the healthcare law last year?
Right.
This is something of that significance because we have this in terms of what's the power of the president. The power of the president, of course, is to nominate folks for high office, and the Constitution provides that he or she must obtain the advice and consent of the Senate for appointments, but the Constitution has one exception, and that is when there are vacancies, when Congress is in recess, then the president has the power to appoint someone on an interim basis, and they will serve until the next congressional session ends. So what happened is that in order to prevent recess appointments, the Congress decided they would remain in session, and while they were in what's called pro forma session, the NLRB reached a point where they didn't have a quorum of members. So, the NLRB has been a political football probably throughout its existence, and President Obama was having trouble getting appointments confirmed, so he named 3 folks to become the members, which would be the majority, give it the quorum. Well, the Court of Appeals held that the appointments were invalid, and therefore the decisions made by the NLRB were invalid, and therefore an unfair labor charge that was rendered by the NLRB was invalid. And the NLRB has made hundreds of decisions since these 3 folks made decisions on everything relating to employment law. And the recess appointments haven't been limited to the NLRB. The agency that Elizabeth Warren set up also has been headed by someone with a recess appointment. So all these presidential appointments and all these actions by administrative agencies are now that people have thought maybe the law of the land may not be.
So, Mark, for the benefit of our listeners, could you describe exactly what power is invested in the NLRB and why it's necessarily relevant to business people, to companies, to employment law, etc.?
Yes, the NLRB has traditionally regulated union-employer relations. However, in recent years, and the NLRB has moved to regulate non-union relations. For example, one of the proposals, one of their requirements, which I think has been stayed pending further appeal, is that all employers post notices informing folks of their right to unionize.